Well, friends, after repeatedly, incessantly telling the American people that he would testify in his criminal trial in New York, when the time came for him to take that witness stand and tell his side of the story, Donald Trump punked out. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, throughout his criminal trial in New York, Donald Trump kept telling us about how he absolutely was going to testify in his own defense. You know, before court started in the morning, during the lunch break, after court broke for the day, Donald Trump would step out into the hallway for what I call his hallway lies sessions, and he insisted over and over again that he will testify. Take that to the bank. He's going to take the stand. He's going to rock the mic. He's going to testify. He promised the American people repeatedly, incessantly. And then when the time came, when he had an opportunity to take the witness stand and convince the jurors that he did nothing wrong, he committed no crimes, Donald Trump punked out. Let's start with the new reporting. This from USA Today. Headline, Donald Trump hush money trial recap. Trump doesn't testify. Defense rests its case. And that article begins, Donald Trump's defense rested its case after calling just two witnesses, neither of them named Donald Trump, in the former president's historic criminal hush money trial on Tuesday. Trump had initially said he would testify in his defense, but subsequently backed out. Okay, friends, let's talk for just a few minutes about a defendant's right to testify in his or her own defense at their criminal trial, and a defendant's absolute right to decline to testify in their own defense. First of all, nobody can compel a defendant to testify in their own criminal trial. Why? Because we all enjoy a Fifth Amendment privilege against self-incrimination. So no one can compel, force, coerce a defendant to take the stand and testify in their own case. So a defendant has an absolute right to decline to testify, a constitutional right, and a defendant also has an absolute right to testify. Of course, if you're going to decline to testify, you probably shouldn't yammer on endlessly, promising everybody that you're going to testify. Absolutely, no question about it. Donald Trump said it over and over and over again to the American people before punking out. Here is another really important principle, perhaps the most important principle as we sort of gauge what it means that Donald Trump decided not to testify after promising over and over again that he would testify. The right to testify or the right to decline to testify, that decision is uniquely and exclusively the defendant's. It is not up to the defense attorneys. There are certain rights that belong exclusively to the defendant, like the right to plead guilty or not guilty, the right to request a jury trial or waive a jury trial and be tried by a judge alone, what we call a bench trial, the right to testify. Now, the defense counsel can certainly advise their client in favor of or against testifying. They can lay out the pros and cons, but it is absolutely the defendant's call, not the defense attorney's call. And it's such an important right reserved for the defendant that judges will ask the defendant, have you made the decision whether to testify or not in your case? And they don't rely on the word of the defense attorney. The judge goes right to the defendant. So the judge can satisfy himself or herself that, yes, this is the defendant's decision to testify or decline to testify. So don't ever let Donald Trump tell you that his attorneys told him he couldn't testify. No, BS. It was your decision in consultation with your attorneys, but it was your decision to make, and you punked out. Put another way, you decided to avail yourself of your Fifth Amendment right against self-incrimination. So now that we know the defense is rested, all of the evidence is in, the defense didn't really put on anything of any consequence. And of course, Donald Trump opted not to try to defend himself from the witness stand in this court proceeding. Interesting choice. Of course, he couldn't have gone 10 seconds without lying, without perjuring himself under cross-examination from a very accomplished team of prosecutors, so it was probably the smarter tactical decision. But friends, I want to spend a few more minutes today talking about something else. A phrase that you all have no doubt heard over and over and over again, probably on TV shows, in the movies, in actual criminal litigation, on TV when folks like me are analyzing the legal issues of the day. And that is the burden of proof in a criminal case beyond a reasonable doubt. That is the mother of all burdens of proof in the criminal law, the highest burden of proof that we have, beyond a reasonable doubt. And jurors have to be persuaded that the evidence proves a defendant's guilt beyond a reasonable doubt if they are to vote guilty. Now, beyond a reasonable doubt is kind of a vague term or phrase. It's not something that we encounter in our everyday lives. You know, we don't go around applying burdens of proof, at least not formally, and certainly not the burden of proof beyond a reasonable doubt. So jurors need to know what that means if they're going to try to decide if the evidence proves Donald Trump's guilt beyond a reasonable doubt. Spoiler alert, it does. So what happens at the end of the trial, after all of the evidence is in and the government prosecutors rest their case and the defense rests its case, the judge will then give the jurors instructions of law. And it's the law that is to be applied to the facts that they find. And what I want to do today is read a standard jury instruction defining what beyond a reasonable doubt means. Each jurisdiction has its own version of this instruction of law defining beyond a reasonable doubt, but they are all largely the same. And I'm going to use the one that I am most familiar with, that I used hundreds of times in the courts of Washington, D.C. when I was prosecuting cases. And here is how the judge's instruction to the jury defining beyond a reasonable doubt goes. The government has the burden of proving the defendant guilty beyond a reasonable doubt. In civil cases, it's only necessary to prove that a fact is more likely true than not, or, in some cases, that its truth is highly probable. In a criminal case, such as this one, the government's proof must be more powerful than that. It must be beyond a reasonable doubt. Reasonable doubt, as the name implies, is a doubt based upon a reason, a doubt for which you have a reason based upon the evidence or lack of evidence in the case. If, after careful, honest, and impartial consideration of all the evidence, you cannot say that you are firmly convinced of the defendant's guilt, then you have a reasonable doubt. Reasonable doubt is the kind of doubt that would cause a reasonable person, after careful and thoughtful reflection, to hesitate to act in the graver or more important matters in life. However, it's not an imaginary doubt, nor a doubt based on speculation or guesswork. It's a doubt based upon reason. The government, the prosecution, is not required to prove guilt beyond all doubt or to a mathematical or scientific certainty. Its burden is to prove guilt beyond a reasonable doubt. clear as mud, friends. I know that when you're trying to define a term like beyond a reasonable doubt, and you choose in part to define it by saying, well, it's a doubt based on reason. I know that's not great in helping clarify exactly what we're dealing with, but that is essentially what the law has come up with. That's a standard beyond a reasonable doubt instruction. And what I always did when I was arguing cases to the jury is I would seize upon the last couple of sentences of the judge's instruction on beyond a reasonable doubt. And I would emphasize to the jurors, ladies and gentlemen, remember what the judge instructed you. It is a doubt based on reason, but the government need not prove guilt beyond all doubt or to an absolute certainty, to a mathematical certainty, to a scientific certainty. It is simply the government's job to prove guilt beyond a reasonable doubt, not to an absolute certainty. But I respectfully submit, ladies and gentlemen, in this case, given the evidence, given the mountain of corroboration of, for example, Michael Cohen's testimony and Stormy Daniels' testimony, you had David Pecker's testimony, you had Keith Davidson's testimony, you had Hope Hicks' testimony, you had business records, false ledger entries, reimbursement checks written by Donald Trump himself out of the Oval Office, falsely, fraudulently, trying to make them look like, payment for legal services. No, you all know, based on the evidence, that Donald Trump was repaying Michael Cohen as part of this dirty hush money scheme to gain unfair advantage in a presidential election. This is a case where you just have to use your common sense and apply it to the evidence you've seen. Because who benefited from this criminal scheme? Not Michael Cohen, Donald Trump. And the evidence has proved, friends, beyond all doubt, not just beyond a reasonable doubt, beyond all doubt, that Donald Trump committed these crimes. And we're simply asking you to hold him accountable for the decisions he made to violate New York state law. Hold him accountable by returning verdicts of guilty. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.